Good evening. On September 17th, 1787, the delegates to the Constitutional Convention met for the last time to sign the wonderful document they had created. We are gathered here tonight to celebrate the 229th anniversary of the formation of the U.S. Constitution. I am deeply honored to have been invited here tonight by Porterville College and its chat program to help observe this important day in our nation's history. I also want to thank each one of you for joining us this evening to honor and celebrate this historic day in America. The Constitution has always been a highly influential and important document in my life. I first was intrigued by the Constitution in high school when I took civics. I was introduced to the Bill of Rights, and we studied the decades-long struggle for civil rights in America. However, when I started my freshman year at college at the University of Minnesota, I had very different plans in life. I enrolled as a pre-med major, taking human sciences and mathematics courses and planning my future. Then in my second semester, completely on a whim, I enrolled in a constitutional law course. From the first day of the course, my life was changed. I became enthralled by the Constitution, and I remain so today. I learned in constitutional law how the Constitution had been used to curtail abuse of power in America and better the plight of millions of Americans. From that point on, I could easily be picked out of a crowd as the only student with a copy of the Constitution sticking out of my back pocket. I constantly discussed the debate of the Constitution with my fellow college students, asking them to point out where in the Constitution you could find the words or thoughts they were sometimes wrongly attributing to it. I still carry one today. I would hold out my pocket Constitution and say, show me where it says that. However, even though I revered the Constitution, I thought of it as a static document, one etched in stone many decades ago that was intended to have a constant and unchanging meaning. However, after changing my undergraduate to political science, changing my undergraduate major to political science, which I encourage all of you to do, by the way. I took a course entitled Civil Liberties. This course changed my life again. It prompted me to start asking the questions: do we have a living Constitution? Do we want a living Constitution? A living Constitution is one that evolves, changes over time, adapts to new circumstances, without being formally amended. When I considered this question, I came to the conclusion that the answer is undoubtedly yes. I believe the evolving values, experiences, and aspirations of our nation should be reflected in the interpretation of the Constitution. Our Constitution, the document under glass in the National Archives, was adopted over 200 years ago. While the Constitution can be amended, we all know the amendment process is very slow and arduous. The difficulty in amending the Constitution can readily be seen in our failure to ratify the Equal Rights Amendment in the 1970s. From my perspective, some of the most important amendments were added to the Constitution almost a century and a half ago, in the wake of the Civil War, during the era of Reconstruction. Since that time, many of the amendments have dealt with relatively minor matters. You may ask, why does America need a living Constitution? Simply put, the world has changed in incalculable ways. The nation has grown in territory. Its population has multiplied several times over. Technology has changed. The international situation has changed. The economy has changed. Social mores have certainly changed. And the political landscape has undoubtedly become more partisan and less effective in remedying social ills. All of these changes have occurred in ways that no one could have possibly foreseen at the time the Constitution was drafted and subsequently ratified. What would happen to our nation if we were forced to wait for the political process to reflect the constitutional values we've lost as we face new challenges and conditions here in America? Excuse me. I believe the notion of a living, breathing Constitution is needed now in America, perhaps more than ever in our nation's history, as the plight of people of color in America continues to deteriorate and the promise of our Constitution to equally protect all Americans remains largely unfulfilled. Excuse me. In light of the overwhelming evidence of the disparate treatment of people of color in our streets and our criminal justice system, I believe we must revisit the legal standard our justice system applies when examining and applying equal protection under the 14th Amendment of the Constitution. The purportedly progressive approach to remedying racial inequality in America has been to mix color-conscious moral invective with colorblind public policy. How has this era of colorblind public policy impacted people of color? One need only tune into the news or read the front page of the paper to see the ill effects bestowed on our society by colorblind public policy. Not only has colorblind public policy dominated the executive and legislative branches since the 1960s, it has also come to permeate judicial thought and decisions. In this era of colorblind public policy, the plight of people of color has been blamed on their moral and familial failings and the purported propensity for violence and crime, notwithstanding the overwhelming evidence of institutionalized racial disparity throughout our criminal justice system. This institutionalized racial disparity exists despite the Constitution's undying promise of equal protection for all under the law. On this day we gather to celebrate the Constitution, I believe it's time we begin a national dialogue on the ramifications of colorblind policy in light of the unfulfilled promise of equal protection to all. The evidence is undisputable that the era of colorblindness has resulted in major setbacks to people of color in the United States. In 1868, following its ratification by the necessary 3/4 of the U.S. states, the 14th Amendment guaranteeing to African Americans citizenship and all of its privileges was officially adopted into the U.S. Constitution. In unambiguous language, the 14th Amendment states, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The 14th Amendment resolved pre-Civil War questions of African American citizenship by stating that all persons born or naturalized in the United States are citizens of the United States and of the state in which they reside. The amendment then reaffirmed the privileges and immunities of all citizens and granted all of these citizens the equal protection of the laws. However, in the decades after its adoption, the Equal Protection Clause remained fairly unfulfilled. The Equal Protection Clause was cited by a number of African American activists who urged racial segregation be overturned because it denied them the equal protection of the law. However, in 1896, the U.S. Supreme Court ruled in Plessy v. Ferguson, a case that hopefully you've all heard of, that states could constitutionally provide segregated facilities for African Americans, so long as they were equal to those afforded white persons. The ideal of a living constitution did not exist at the time. If we did not have the ideal of a living constitution today, our children might still be attending segregated schools, and persons of color might still be eating at separate lunch counters. According to Chief Justice Taney, in the Plessy v. Ferguson opinion, the Constitution recognized the inferior status of blacks by the adoption of the 3/5 clause of Article 1, Section 2, which declared that for the purpose of determining congressional representation, enslaved blacks would be counted as only 3/5 of a person in population counts. This cruel treatment of African Americans was established during the original Constitutional Convention and remained in place by law until the passage of the Civil War amendments, the 13th Amendment banning slavery, and the 14th Amendment, which purported to grant full citizenship and equal protection under the laws to all born on American soil, regardless of ethnicity. The decision of Plessy v. Ferguson, which announced federal toleration of so-called separate but equal doctrine, was eventually used to justify segregating all public facilities, including railroad cars, restaurants, hospitals, schools, in essence, creating apartheid here in America, a legal system of separateness. The marks of this separateness still remain on America today. However, colored facilities were never equal to their white counterparts, and African Americans suffered through decades of debilitating discrimination and humiliation in the South and elsewhere in the United States. Fortunately, in 1954, Plessy v. Ferguson was finally struck down by the Supreme Court in the landmark historic ruling in the case Brown versus the Board of Education of Topeka, Kansas. In Brown, in a unanimous 9-0 decision, the Supreme Court held that separate but equal facilities are inherently unequal and violate the protections offered by the Equal Protection Clause of the 14th Amendment. The decision in Brown embodies this notion of a living, breathing Constitution, and it cannot be fully understood apart from the specific historical setting in which the decision was rendered. At the time, we had our victory over the racist Nazi regime in the Second World War. At the time, we saw the rise of the Soviet Union. We saw the integration of the American military, the urgent need for workers after the end of the Second World War, and there was also important demographic changes occurring in the United States. The court in Brown also found that segregation based on race instilled a sense of inferiority that evidenced disparate impact on the education and personal growth of African American children. Since the decision in Brown, equal protection under the law demands that our government justify any distinction it draws based on ethnicity. The decision in Brown offered great promise for our nation, but I question if that promise has been fulfilled. Disparate impact refers to policies, practices, rules, or other systems that appear to be neutral and colorblind, but result in disproportionate negative impacts on protected groups, such as persons of color. Disparate impact involve consideration of disproportionate outcomes for individuals who would otherwise qualify for protection as a class. Disproportionate impact claims have provided significant assistance to persons of color because such claims acknowledge that race matters, and that we can examine the disproportionate outcomes to persons of different races to infer, whether consciously or subconsciously, that race was a consideration in the practices that led to the racial disparities. However, in America today, disparate impact theory is only available for statutory claims, such as those arising in employment cases under Title VII of the Civil Rights Act of 1964. It is not available for constitutional claims, including those arising under the Equal Protection Clause of the 14th Amendment. I stand here tonight in front of you believing this needs to change. In the case of Washington v. Davis, two applicants, two black men who were applying for jobs at the police force in the District of Columbia, were rejected for the job. The two men filed suit against the mayor, Walter Washington. The men alleged that the department's recruiting procedures, including a written personnel test, discriminated against racial minorities. They claimed that the test was wholly unrelated to the job performance and intentionally excluded a disproportionate number of black applicants. Under these facts, the Supreme Court examined the question, does an employment test that results in a higher failure rate among black candidates deprive them of their equal protection rights? The court found that the impact or outcome of the test may disproportionately disadvantage African Americans, but that it did not violate equal protection, because it lacked a discriminatory intent and purpose. Specifically, the court found that constitutional claims based on disparate impact alone would receive rational basis review rather than the highest standard applied by the court when reviewing a test or a law, strict scrutiny. Under the rational basis test, courts will uphold the law if it's merely rationally related to a legitimate government purpose, even if it has a disparate impact on persons of color. In a rational basis analysis, the challenger of the constitutionality of the statute has the burden of proving that there is no conceivable legitimate purpose for the test or law, nor is it rationally related to it. Under rational basis examination, it is virtually impossible for a challenger to meet the standard. On the other hand, the standard the court refused to apply, strict scrutiny, requires that the government prove it has chosen a narrowly tailored means to achieve a compelling governmental interest. Under this test, the burden is on the government to prove that it has a compelling objective and that there are no equally less restrictive alternative means to accomplish this objective. In proving the existence of a compelling objective, the government cannot simply assert it has an interest. It must show the compelling objective is the real reason for its action, its law, or the test, and that the objection is actually at risk if it refrains from regulation. The holding in Washington v. Davis assumes that disparate outcomes are no longer caused by racism and ushered in an era of colorblindness in equal protection enforcement and analysis that's still with us today. Do we see unaddressed racially disparate impacts in today's society? Unfortunately, I believe the unassailable answer is yes, as such impacts permeate today's society. In Furman v. Georgia, a 1972 Supreme Court case, in a 5-4 decision, the Supreme Court issued a one-paragraph per curiam opinion. That's where there's no majority opinion, because the justices can't really agree on what the rule of law should be. However, this per curiam opinion did hold that the imposition of the death penalty constitutes cruel and unusual punishment and is violative of the Constitution. There was no controlling opinion in Furman because none of the 5 justices could agree with any of the opinions authored by the other justices. The Furman case arose from the death sentence given to 3 young black men, William Henry Furman, Lucius Jackson, and Elmer Branch. In Furman, Justices Potter Stewart, Brian White, and William O. Douglas expressed concerns about the apparent arbitrariness with which death sentences were imposed under the existing laws, often indicating a racial bias against black defendants, writing that these death sentences are cruel and unusual in the same way that being struck by lightning is cruel and unusual. For of all the people convicted of rapes and murders in 1967 and 68, many just as reprehensible as these, the petitioners are among a capriciously selected random handful upon whom the sentence of death has in fact been imposed. My concurring brothers have demonstrated that if any basis can be affirmed for the selection of these few men sentenced to death, it is the constitutionally impermissible basis of race. But racial discrimination has not been proven, and I put it to the side. I simply conclude that the 8th and 14th Amendments cannot tolerate the infliction of a sentence of death under a legal system that permits this unique penalty to be so wantonly and freakishly imposed on persons of color. In the 4 years following Furman, 37 states enacted new death penalty laws aimed at overcoming the court's concerns about arbitrary and racially motivated imposition of the death penalty. Several states mandated bifurcated trials with separate guilt determination and sentencing phases and imposed standards to guide the discretion of judges and juries in imposing capital sentences. In 1976, the Supreme Court heard the appeal of 5 death sentences in the case Grieg versus Georgia. These sentences were given out under the revised death penalty statutes of Georgia, Florida, Texas, North Carolina, and Louisiana. In Grieg, the Supreme Court upheld each of these death penalty sentences. In doing so, the court set out 2 broad guidelines that legislatures must follow in order to craft what it considered a constitutional capital sentencing scheme. First, a capital sentencing scheme must provide objective criteria to direct and limit the death sentencing discretion. The objectiveness of these criteria must then, in turn, be ensured by a repellent review of all death sentences. Second, the capital sentencing scheme must allow the sentencer, whether judge or jury, to take into account the character and record of the individual defendant. Many legal scholars today believe that this criteria allows jurors in the sentencing phase of a capital trial to consider the race of the defendant as a factor in considering whether the death sentence should be imposed. The court found that the capital sentencing schemes of Georgia, Florida, and Texas, respectively, met the criteria, whereas the sentencing schemes of North Carolina and Louisiana did not. In 1987, the Supreme Court heard one of its most infamous cases, McCluskey v. Kemp. McCluskey was the most far-reaching case ever in front of the court involving race and the death penalty. McCluskey has been named one of the worst Supreme Court decisions since World War II by most legal scholars in the United States. In a New York Times column 8 days after the decision was rendered, General Anthony Lewis, twice the winner of the Pulitzer Prize and one of the most respected legal journalists that's ever lived in America, Mr. Lewis charged that the Supreme Court had effectively condoned the expression of racism in a profound aspect of our law. Similarly, law professor Anthony G. Amsterdam called it the Dred Scott decision of our time. Warren McCluskey was convicted of 2 counts of armed robbery and 1 count of murder in the Superior Court of Fulton County, Georgia. McCluskey was African American. His victim was a white Atlanta police officer. At McCluskey's sentencing hearing, the jury found 2 aggravating circumstances existed beyond a reasonable doubt. The murder was committed during the course of an armed robbery, and the murder was committed upon a police officer while the officer was engaged in his law enforcement duties. A finding of either of these aggravating circumstances was sufficient to impose the death penalty, and the jury recommended death. The court followed the jury's recommendation and sentenced McCluskey to die. On appeal to the federal courts, McCluskey alleged the state's capital sentencing process was administered in a racially discriminatory manner in violation of the Equal Protection Clause of the 14th Amendment. McCluskey based his claims on a study conducted by jurists David Baldus, Charles Pulaski, and statistician George Woodworth, which demonstrated that racial considerations most undoubtedly enter into capital sentencing determinations. Baldus, a professor at the University of Iowa College of Law, studied 2,500 murder cases in Georgia. The Baldus study concluded that individuals convicted of murdering whites were far more likely to receive the death penalty than those convicted of murdering blacks, thereby establishing that the application of the death penalty in Georgia was linked to the race of the victim. One of his models concluded that even after taking into account 39 non-racial variables, defendants charged with killing white victims were 4.3 times more likely to receive a death sentence than defendants charged with killing blacks. Nonetheless, the Supreme Court found that statistical evidence showing one racial group receives a disproportionate amount of death sentences as opposed to other groups is not a sufficient basis to challenge a state death penalty under the Equal Protection Clause of the 14th Amendment. Rather, the court held the defendant must prove the presence of actual racial discrimination in his own case. Colorblind jurisprudence had struck yet another blow under the equal protection of persons of color. In his blistering dissent, Justice Blackmun argued the Baldus study demonstrated a clear pattern of disparate impact in imposing the death sentence on the basis of race, and that the defendant had met his burden of showing purposeful discrimination through the statistical evidence presented to the court. And Justice Blackmun believed the burden should then have shifted to the government to prove that the allegations of racial bias were untrue. McCluskey v. Kemp has had far-reaching effects on claims far broader than those under the death penalty. McCluskey has been used to establish the proposition that claims based on governmental denial of equal protection of the laws to racial minorities will fail unless something more than disparate impact can be shown. Michelle Alexander, the award-winning author of the book The New Jim Crow, has criticized the decision in McCleskey, stating, McCleskey v. Kemp has immunized the criminal justice system from judicial scrutiny for racial bias. It has made it virtually impossible to challenge any aspect of the criminal justice process for racial bias in the absence of the proof of intentional discrimination and conscious, deliberate bias. Evidence of conscious, intentional bias is almost impossible to come by in the absence of some type of governmental admission. But the U.S. Supreme Court has said that the courthouse doors are closed to claims of racial bias, and that in the absence of evidence of intentional discrimination, our actors under the criminal justice system are immunized from the discriminatory conduct. Anthony Lewis of the New York Times wrote of the decision in McCleskey, confronted with powerful evidence that racial feelings play a large part in determining who will live and who will die, the court chose to close its eyes. It effectively condoned the expression of racism in a profound aspect of our law. Of Justice Powell's majority decision, Lewis wrote, McCleskey challenges decisions at the heart of the state's criminal justice system. In other words, to confront the reality of racial influence on death sentences would risk disturbing the system too much. It is tempting to pretend that minorities on death row share a fate in no way connected to our own, that our treatment of them sounds no echoes beyond the chambers in which they die. Such an illusion is ultimately corrosive, for the reverberations of injustice are not so easily confined. The way in which we choose those who will die reveals the depth of our moral commitment among the living. In his argument to the Supreme Court, McCleskey did not rely solely upon statistical evidence of racial disparities in his attempts to establish discrimination. He also relied on historical evidence supporting the inference of invidious government intent. This evidence focused on the discriminatory laws enforced in Georgia during and after the Civil War that mandated the unequal treatment of Black Americans. However, the court also rejected this evidence, finding in a footnote to the decision that unless the historical evidence is reasonably contemporaneous with the challenged decision, it has no merit and little value. The court also noticed that the history of racial discrimination in this country is deniable, but the court opined that it cannot accept official actions taken long ago as any evidence of discriminatory intent. Taken on its face, many legal scholars believe that the court's unwillingness to regard McCleskey's evidence as sufficient was based in part on the fear that recognition of McCleskey's claim would open the door to widespread challenges to all aspects of criminal sentencing due to racial disparities. Like an avalanche, racial disparity grows cumulatively as people traverse our criminal justice system. Myriad criminal justice policies that appear to be colorblind collide with broader socioeconomic patterns to create a disparate racial impact. Sentencing laws that are designed to more harshly punish certain classes of offenses or to carve out certain groups from harsh penalties have had a disparate impact on persons of color. This occurs because of how sentencing laws interact with broader differences in our society and within the criminal justice system. There are significant racial disparities in sentencing decisions currently in the United States. Sentences imposed on Black males in the federal system are nearly 20% longer than those imposed on white males convicted of the same crime. Black and Latino offenders sentenced in state and federal courts face significantly greater odds of incarceration than similarly situated white offenders and receive longer sentences than their white counterparts. Black male federal defendants receive longer sentences than whites arrested for the same crimes and with comparable criminal history. Race also continues to play a significant role in the determination of which homicide cases result in death sentences. The racial disparities increase with the severity of the sentence imposed. The level of disproportionate representation of blacks among prisoners who are serving life sentences without the possibility of parole is higher than that among parole-eligible prisoners serving life sentences. The disparity is even higher for juvenile offenders sentenced to life without the possibility of parole, and higher still among prisoners sentenced to life without the possibility of parole for nonviolent offenses. Although Black Americans constitute only 13% of the U.S. population, blacks constitute 28.3% of all persons given life sentences in the United States. 56.4% of those serving life without the possibility of parole sentences. 56.1% of those who receive life without the possibility of parole for offenses committed while they were juveniles. As of 2012, the ACLU's research shows 65.4% of prisoners serving life sentences without the possibility of parole for nonviolent offenses are Black Americans. In 13 states in the federal system, the percentage of blacks serving life sentences is over 60%. In Georgia and Louisiana, the proportion of blacks serving life sentences without the possibility of parole is as high as 73.9% and 73.3% respectively. In the federal system, 71.3% of the 1,230 life without the possibility of parole prisoners are Black Americans. African Americans now constitute nearly 1 million of the total of 2.3 million incarcerated population in America. African Americans are incarcerated at nearly 6 times the rate of whites. Together, African Americans and Hispanics comprise 58% of all prisoners in America, even though African Americans and Hispanics make up only 1/4 of the U.S. population. According to a study done by Unlocking America, if African American and Hispanics were incarcerated at the same rate as whites, today's prison and jail populations would decline immediately by 50%. Currently, 1 in every 6 black men in the United States are incarcerated. If these trends continue, 1 in every 3 black males born today can expect to spend time in prison during his lifetime. These racial disparities result from the disparate treatment of blacks at every stage of the criminal justice system, including stops and searches, arrests, prosecutions, plea negotiations, trials, and finally at sentencing. Race matters at all of these phases and in all aspects of the criminal process, including the quality of representation, the charging phase, and the availability of plea bargains. Yet at the same time, our laws pretend to be colorblind under Equal Protection Clause jurisprudence. Judges and juries are prohibited from considering the glaring evidence of the disparate impacts being suffered by minorities at the present time in our criminal justice system. Racial disparities are particularly pronounced under cocaine sentencing laws. As part of the Anti-Drug Abuse Act of 1986, Congress ignored empirical evidence and created a 100-to-1 sentencing disparity between the amounts of crack and powder cocaine required to trigger certain mandatory minimum federal prison sentences. Crack and powder cocaine are simply 2 forms of the same drug. The only difference between the two is that crack includes the addition of baking soda and heat. However, sentences for offenses involving crack cocaine were made much longer than the offenses involving the same amount of powder cocaine. Thus, for example, someone convicted of an offense involving just 5 grams of crack cocaine was subject to the same 5-year mandatory minimum federal penitentiary sentence as someone convicted of an offense involving 500 grams of powder cocaine. The 100-to-1 ratio resulted in vast and unwarranted racial disparities in the average length of sentences for comparable offenses because the majority of people arrested for crack offenses are Black Americans. By 2004, under this 100-to-1 racial sentencing disparity, Black Americans served virtually as much time in prison for nonviolent drug offenses, approximately 58.7 months, as whites did for violent offenses. In 2010, 85% of the 30,000 people arrested and sentenced for crack cocaine offenses under the 100-to-1 sentencing regime were African American. In 2010, in long overdue recognition of the unfairness of the sentencing disparity, Congress passed the Fair Sentencing Act, which reduced the disparity between the amount of crack and powder cocaine required to trigger mandatory federal sentences from 100-to-1 to 18-to-1. Unfortunately, despite Congress's determination that the previous crack cocaine penalties under which thousands of defendants were sentenced were unfair, today over 16,700 prisoners, most of whom are black, are still serving long sentences under the 100-to-1 sentencing regime. Racial bias continues to taint our capital punishment system in the United States, from jury selection through decisions about who faces execution. The death penalty is disproportionately imposed on people of color. As of January 1st, 2014, 42% of defendants under the sentence of death in the United States were black, although blacks make up only 13% of our overall population. Numerous studies across the country conclusively demonstrate that the murder of whites results in capital punishment at far higher percentages than the murders of people of color. Despite the U.S. Supreme Court's longtime prohibition on the discrimination in jury selection arising from its decision in the seminal case, Batson versus Kentucky, people of color continue to be excluded from capital juries at alarming rates. A recent study of capital trials in North Carolina showed that prosecutors used peremptory strikes to remove qualified black jurors at more than 3 times the rate that they excluded all other jurors. Of the 159 prisoners currently on North Carolina's death row, 31 were sentenced to death by all-white juries, and another one had only one person of color on his sentencing jury. In 2009, in response to the McCleskey decision, North Carolina passed the Racial Justice Act, which is considered very radical in its nature. This legislation requires courts to enter a life sentence for any death row defendant who proved that race was a factor in the imposition of his or her death sentence, and allow the defendant to show evidence of racial bias with statistical evidence. In a historic ruling based on the Racial Justice Act in April 2012, a judge found intentional and systematic racial discrimination in the determination of the death sentence for Marcus Robinson, a black American death row prisoner, and commuted his sentence to life imprisonment without the possibility of parole. North Carolina courts set aside 3 more death sentences in the next 2 months under the Racial Justice Act for the same reason, again based on statistical evidence showing racially disparate impacts. However, in June of 2013, the North Carolina legislature repealed the Racial Justice Act. The state of North Carolina has appealed the cases of all the prisoners who won relief under the Racial Justice Act to the North Carolina Supreme Court, where they currently remain pending. Racial profiling is at the heart of American law enforcement. Racial profiling is a practice of targeting individuals for police or security detention based on their race or ethnicity in the belief that certain minority groups are more likely to engage in unlawful behavior. If law enforcement adopts a policy or employs a practice, or in a given situation takes steps to initiate an investigation of a citizen based solely on that citizen's race, without more, that constitutes a violation of the Equal Protection Clause, at least theoretically. In the United States, police commonly use a tactic known as Terry stops for investigations. A Terry stop is a brief detention of a person by police based on the reasonable suspicion of that person's involvement in criminal activity. But, however, no probable cause is needed. The name of the stop derives from the case Terry v. Ohio, in which the Supreme Court of the United States held that police may briefly detain a person who they reasonably suspect is involved in criminal activity. In Terry, the Supreme Court also held that police may do a limited search of the suspect's outer garments for weapons if they have a reasonable and articulable suspicion that the person may be armed and dangerous. To have a reasonable suspicion that would justify a stop, a police officer must be able to point to a specific and articulable facts that would indicate to a reasonable police officer that a crime has been, is being, or is about to be committed. Accurate information regarding Terry stops is very hard to obtain, so we don't really know how most police forces implement Terry stops. However, New York City is an exception. Every time a police officer stops a person in New York City, the police officer is required to fill out a form to record the details of the stop. Officers fill out these forms, hand them in, and the forms are manually entered into a database that's accessible to the public. As a result, we have a very good view of what the police do in New York, and we have accurate information regarding who New York police are stopping and frisking under Terry v. Ohio. What does that information tell us? In 2012, New Yorkers were stopped by the police 532,911 times. Of those stops, 284,229 were black, constituting 55% of all stops. 165,140 were Latinos, constituting 32% of all stops, while only 50,366 of the stops were white. In 2013, New Yorkers were stopped by the police 191,558 times. Of those stops, 56% of the people detained and frisked were black, 26% were Latino, 11% were white. In 2014, New Yorkers were stopped by the police 45,787 times. Of those stops, 53% of the people stopped and frisked were black, 27% were Latino, while only 12% were white. Finally, for the last year we have statistics in 2015. New York police stopped 22,939 people. Of those stops, 54% of those people stopped and frisked were black, 29% were Latino, and 11% were white. As a result of the decision in McCleskey and his progeny, proof of discriminatory intent is an essential element, I'm not used to talking this long, essential element of any equal protection claim. In the case of a Terry stop, to establish an equal protection violation, one must have direct evidence of a discriminatory intent or show that there was no objective, non-racially motivated basis for the police officer to have made the stop or detention. This is yet again an impossible standard to meet for those who believe they were detained and searched simply because of the color of their skin. Despite the overwhelming statistical evidence of a disparate impact on African Americans, Terry stops remain a commonly used investigative tactic that today is largely immune from constitutional attack under the Equal Protection Clause. In light of the overwhelming evidence showing endemic racial bias throughout our criminal justice system, I believe it is time for the Supreme Court to revisit equal protection standards. In order to address the systemic racial bias in our system, I believe the Supreme Court must move beyond colorblind jurisprudence and allow defendants to use statistical evidence showing disparate impact to establish discriminatory intent. Otherwise, we will continue to see rampant racial bias in our criminal justice system that cannot be remedied under the Equal Protection Clause. This unremedied bias is threatening to undermine the legitimacy of our entire criminal justice system. It is time for our courts to accept evidence of disparate impact as evidence of intentional discriminatory intent. As Justice Harry Blackmun wrote many years ago, to get beyond racism, we must take race into account. For equal protection to truly become the law of the land, we must reject colorblindness as a legitimate constitutional standard and instead take race into account. Otherwise, the disparate impacts currently being suffered by persons of color in our criminal justice system will increasingly worsen and continue to wrongly deny the equal protection of the law demanded by the 14th Amendment to millions of our citizens for whom the Constitution should offer hope. On this day we celebrate the Constitution. I ask that you join in the call to abandon the colorblind policy currently being practiced by our courts, as this is the only way we can truly make equal protection for all the law of the land. I believe the stakes are high, and I hope you will all join me in that cause. Again, thank you very much for joining us here at Porterville College in celebration of our Constitution.